The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we welcome your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Bart Siniard is on the list of best lawyers in America 3 years running, and Tommy Siniard has more than 3 decades of recognition by best lawyers in America. And Tommy, tonight we have an expert attorney on child custody cases.
Yeah, real happy to introduce Coby Boswell, whose dad was a lawyer, and this is how old I am. I'm more of a contemporary of his dad than I am Coby. Coby's proven to be an excellent lawyer, and he practices in the area of family law, divorce, child custody, and the like, and does a hell of a job. He started in 2012, graduated from the Birmingham School of Law, is that right?
That's correct.
And then primarily has been in the field of domestic relations, bless his heart, up to and through now, and he started Next Up Law, which is really one of the premier divorce, child custody, family law firms in North Alabama, and they actually do work all over North Alabama, not just in Madison County.
That's correct.
Welcome to the Siniard Law Show.
Thank you guys for having me. I really appreciate it.
See you, Coby.
Absolutely.
Coby, we're taking up the topic of child custody. That's got to be one of the most painful areas of law. Give us your read.
It's hard for people, but what I tell people is generally speaking, somebody has had some experience with family law, whether it be you personally or somebody in your family, so it touches everybody. And so it's kind of important for everybody as a result.
It's interesting what you said, Coby, that after COVID, things seem to really heat up in terms of domestic law.
I think that sheltering in place with everybody didn't do a lot of good for a lot of the relationships for people. I think that a lot of it either made or broke some relationships. And I also think that for some reason, it just kind of changed people's mindset. People have been a lot less tolerant of others since COVID. At least that's been my experience in the family law.
I'll get in trouble for saying this, but my wife shut me down from going anywhere at COVID. And I say this: absence makes the heart grow fonder. The flip side of that nobody mentions is familiarity breeds contempt.
And generally, a call to me.
Yeah. So we've survived it, but boy, it was no picnic for anybody, I'm sure.
Well, we invite you to share your legal questions about child custody cases or any topic of the law. Just email questions@siniardlaw.com or call us at 844-7000-LAW, and your question may be featured. Now to our legal tip of the week. What is the difference between legal custody and physical custody, Coby?
I get this one a lot. And most of the time when people talk about custody, they're talking about physical custody. That's what most people think of when they think of physical custody. That's where your child primarily resides, okay? Whose house do they spend the more time at? What school district they're involved in, things such as that. Legal custody involves the decisions with respect to your children. So, where they go to school, if they're going to a school outside of that school district, a private school. Sometimes medications, so medical decisions with respect to your child. Your child's diagnosed with ADHD. Are we going to utilize medicine? Are we not going to utilize medicine? What sports or extracurricular activities your child participates in. Those are the decisions that involve legal custody. And so when we talk about custody, most people are familiar with custody and think of the physical part, but decisions are something that we discuss, and we have to determine a tiebreaker or a decision maker in each one of those categories.
Oh, that can get complicated. Let's move on to our viewer questions. The first question tonight comes from Suzanne.
I have someone that is paying child support to a lady, and she will not let him see his child, even though he's kept faithfully paying his child support, and she's even remarried. But so he hasn't seen his child in like 5 years, and he knows it's going to cost him money to go to a lawyer. I did not know if there was any other way cheaper than a lawyer to do it, like calling the sheriff and asking for a wellness check, or just they have to hire a lawyer, man up, pay the money so they can see the child again.
So that's one I get a lot, okay? And let's start with, under Alabama law, child support or payment of child expenses and visitation are not linked to each other. So you can be ordered to pay child support and not have a visitation order, never pay your child support and still be entitled to the visitation, and vice versa, okay? They are not linked together. Now, there are recourse if you're not paying child support and things like that. In this situation with this young lady, what it sounds like to me is that the gentleman went to court and they established a child support order for him, but he did not establish a visitation schedule. And without a schedule or the court determining what your access is, he doesn't have an order to effectuate any kind of visitation. So, to answer her question, unfortunately, there is no way around it other than him going and filing an action. In her scenario, there were two things that I drew some concerns with. One, the welfare check is something that you utilize if you believe a child is in danger. It is not to just get access to a child. And what I don't think people realize is that the police go out, they want to talk to your child, they will pull your child out of the house and go talk to your child. It is invasive and sometimes traumatizing to a child. So I certainly don't recommend that unless it's under egregious circumstances. But in this particular case, it sounds like to me, they had an informal arrangement for his access. The mother of that child remarried. She stopped that informal access. His only recourse at this point is to go to the court and ask the court to establish a schedule. He has rights. He can establish those rights. But until he does, he's not entitled to enforce any schedule.
Let's go a step further in a fact pattern. Let's assume that when this couple went to court, there was an order to pay child support, but there was likewise an order for visitation. If she's withholding visitation against an order, what is his recourse? They're saying with or without a lawyer or both.
Well, certainly if he has an order of visitation, that changes the calculus a lot. At that point, the welfare check or utilizing the police department, if you can't get access to your child, that is acceptable at that point. You're going to call to try to exercise your visitation. You can try to utilize the police if your order allows for it. Most of the time, they're not going to get involved in a custody dispute. So regardless, it may end up going back to the court and filing a contempt action, which you're saying, judge, court, he is not following the court order, or she is not, I need to enforce my visitation. You're still going to have to go and seek some sort of remedy or some sort of help from somebody, whether that be first through the police or through the court. But if you have a visitation order, the other person, the mother in this scenario, she's going to have to explain why she's withholding that child.
And is there a financial penalty for her withholding visitation, or what's the consequence in terms of her being in custody or paying a fine?
Well, contempt can run the gambit of things. The court can punish you for 5 days in jail for each time that you violate their court order. They can institute financial penalties, paying attorney's fees. In this scenario, if she is continuously withholding the child, the court could change the custody and place custody with the dad in this scenario. And so the games with respect to children have a lot of consequences attached to it. So I tell people, be careful with that.
So for this lady, it sounds like the cheapest way would be see if you could get the police involved. And secondly would be you'd have to pay a lawyer. So give her an idea of what the cost would be for a lawyer for such a task.
The most expedient way probably would be to involve the police if they will assist.
Which is costless.
Should be costless as far as that goes. Now, it may not be painless, but it may be costless. With respect to modification actions, it kind of varies. I'll give the it depends answers that attorneys give. My hourly rate right now is $350 an hour. Our paralegals charge half of that. I see attorneys charge anywhere from $250 all the way up to $600 an hour. So it kind of just depends on what attorney you go to and what type of case you have. You're looking at probably, if you're going in to modify a current order or hold somebody in contempt, you're probably looking at a minimum retainer of, at least $3,000 or $5,000.
Yeah. Okay, that's good.
Thank you very much. When the Siniard Law Show returns, Scott Garrett, the Dean of the Birmingham School of Law, will share what to expect when going to law school. If you or anyone you know has interest in becoming a lawyer, stick around.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
Have you ever been interested in going to law school yourself? It's very possible, and Tommy Siniard has a special guest with him to tell us how. Tommy?
Thank you, Aaron. We're fortunate to have with us this evening Scott Garrett, who is the Dean of the Birmingham School of Law in Birmingham and now in Huntsville. We'll talk about that in a minute. But Scott, welcome to the Siniard Law Show.
Thrilled to be here. Thank you for having me.
You're the Dean of the 4th law school in the state of Alabama and distinguish the Birmingham School of Law from the other 3.
Well, it's a non-traditional program, and we have weeknight classes and a full-blown Saturday program. You can actually obtain your law degree and never take a class on a day in 4 years, and never take a class on a day that's not Saturday.
Wow.
And so we have several students from all over the state.
Including my son, Riley.
Riley Siniard it drives in now and is in the Saturday program every Saturday.
And so how many students in the Birmingham School of Law?
We have right around 340 right now. And oddly enough, Tommy, we're split right down the middle. Like 50% on the weeknight and 50% on Saturday.
Okay, so the options, and this is unusual, folks, because when I went to law school, you went 5 days a week and typically 3 to 4 hours of classes a week. But to accommodate those who are going back to law school, who might be businessmen or older, the Birmingham School of Law has made it available for you to go either weeknights, 3 weeknights a week for roughly, 4 hours?
It's 2 hours and 45 minutes, okay. 3 nights a week.
3 nights a week. And that has been done here in Huntsville as an experiment?
We're calling it a pilot program.
Pilot program.
And the Cochran firm is nice enough to loan us a room in their carriage house.
Doug Fees.
Doug Fees, that's right. Doug and Ginger Fees, great people.
Right.
And so we've got about 15 students in the Huntsville program right now that'll take they're in their fall term this term. They'll do spring at the Cochran firm, and then next summer they'll fall right into whichever weeknight or Saturday program they prefer.
Right.
Usually it's
unlike traditional law schools, this program by its nature has to stretch out over 4 years as opposed to 3.
That's correct. And we go year round.
Okay.
It's 3 trimesters per year.
And it's tough sledding for somebody, but it's people that want to change professions or increase their skills.
Reinvent themselves or enhance their existing career, absolutely. And They might want to change careers altogether.
But the curriculum is very similar to what you would find in traditional law schools.
That is correct.
Right.
I mean,
and I understand this year, for the first year, the Birmingham School of Law has been invited to participate in the Jessup International Moot Court.
International Law School Association's moot court competition.
That's a big deal. And tell the listening audience what moot court is.
Well, moot court is separate from a mock trial situation. A mock trial it's a simulated trial. You actually put on witnesses. In this situation, we're going to write about a 20-page brief that we'll submit.
Appellate brief
that we will
submit. There's a big difference in going to trial and arguing a case on appeal.
That's right.
And tell us how that's different.
That's different because you will defend your position in the paper that we submit in January in early March to a panel of judges where, the judges can ask whatever they want.
Virtually anything.
Virtually anything.
Appellate judges.
And you've got to be ready to defend your position.
And unlike trial, the only thing that appellate judges decide on are the judicial mistakes that might have been made in the actual trial.
That's right.
And rulings and evidence that's admitted or denied, et cetera.
Correct. And this is it's a brand new endeavor for us. We've never done an international law competition before, so we're all learning a lot.
I understand my son Riley was picked to be in it, and he's got to put his gas pedal down, doesn't he?
Yes, he does.
So
I personally picked Riley.
Did you? Well, that's good to know. The it's extracurricular or just given de minimis amount of hours credit for.
Right. Well, it counts as a full-blown elective at the end of the day.
It does.
Yes.
Okay.
And
well, because it a huge amount of time.
It
effort,
is an absolute huge amount. It is a lot of effort. I appreciate all the students who are participating.
I did moot court and didn't win as a competition within the school then, and but I did do trial ad and mock trials and won that competition.
Well, there you go. Fantastic.
And I got a lot out of it. You know, the legal profession has an absence of clinical things, clinical programs, whereas doctors are laying hands on patients. They just release lawyers to the unsuspecting public.
Yes,
with not much clinical.
Yes, they do
stuff. So, are you enjoying your job?
I absolutely love my job.
Tell us.
It's a labor of love for me, and it always has been and always will be.
And you're a graduate of the Birmingham School.
I am the first dean of Birmingham School of Law to actually be a graduate of Birmingham School of Law.
That's
I'm
awesome.
very proud of that.
And
we've been around for 110 years.
So unlike regular law school, what are your demographics skew much older than regular
Our
law
average
school?
age, Tommy, is about 34, 35, but the one common theme, almost all of Birmingham School of Law students are career folks. They have families. And so they're
doing this in addition to full-time jobs
and their full-time families. And it's
no picnic.
It is no picnic, and they have to be dedicated, very dedicated.
Like other law students, at the end of their academic journey at the Birmingham School of Law, they have to sit for the bar. Tell us what that entails.
That's correct. That's to study for the bar properly, a traditional route, it's about a 10-week program, and like there are several bar review companies out there, Barbary to name one, Kaplan to name another, Themis is out there, and it's a 10-week scripted program, intensive program that you're supposed to treat like a full-time job. Of course, my students have a difficulty with that because they generally can't afford to take 2 months off.
Right. The problem with the bar is you can go to all this school and still not get the ticket, as we call it.
That's correct.
And if you don't pass the bar, how many times can you take it now?
There is no limit to the number of times you can take it.
Okay, it was 5 when I came through.
Alabama State Bar.
Thank God I passed it the first time.
There you go.
But if you had a student that was unable to pass first time, they could continue to try to take it.
And yes.
And it's offered twice a year.
Twice a year in February and July.
In terms of mix of men to women, I know more women are going to law school far and away than when I was there.
Absolutely, and it is a trend that this is not a secret trend. This is a real, it is real. I see it every day. We're about 60-40 now.
Women over men.
Women over men, that's
wow.
Right.
So I tell people about our bench here in Huntsville. There used to be one female lawyer in Huntsville, and they made her a judge. Jerry Blankenship, and she did get so good, we started going, well, we need more of these.
Right.
And now more than half of our bench is ladies, and they do a hell of a job.
I need to get more familiar with the Huntsville bench.
Yeah, I mean, it's pretty colossal. Well, we're grateful for your time here. And
well, I appreciate you having me.
Anytime you come back here, and appreciate what you're doing with Birmingham School of Law.
Well, I appreciate you. Thank you so much for having me.
All right, thank you.
Thank you, Tommy. When the Siniard Law Show returns, we'll get to more of your legal questions, and we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code or sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. We have an email from Tina. She says, my daughter has sole custody of her son, but the child's father is trying to get the original judge's order changed to allow him joint physical custody. He has drug issues, and I don't want this to happen. His parents are paying for him to have a lawyer. He doesn't have the money to even help take care of my grandchild. So what do you think about this one, Coby?
This is pretty common, actually, as far as this goes. Once the court has established that one parent has custody versus the other, the starting point is both parents come in on equal footing, right? So both parents in an original action, if the court's never decided it, they're going to consider both parents equally to determine where custody should go. But once the court determines that one parent should have custody and the other parent should have access or visitation to that child, the burden shifts, and it's a much higher burden to come back to court to change that burden. There's a case, it's called McClendon. It's a pretty heavy burden. I generally say it's one of the harder burdens under our law to meet. You have to be able to establish that not only it's in the best interest of your child to change custody, but that the disruptive effect of taking your child from one home and putting your child in the other home is outweighed by those best interests. It's a really high burden. In this fact scenario, if he has drug issues, he is not paying his child support and supporting his child, the likelihood of him being able to establish even that the best interest of his child is served by a change of custody is slim, but certainly meeting the disruptive effect. It seems unlikely in that scenario. Now, obviously, there may be other factors that would factor into that decision, but just based on this fact pattern, it seems unlikely he would be successful in changing that custody. And the reason for that being, our court's preference when we're dealing with kids is consistency and stability. We do not change households on a whim. We do not change it every time that some circumstance changes. It has to be something material and significant. Otherwise, it is disruptive to kids. And we don't want them going back and forth between households every time something changes with respect to one parent.
I've seen some judges have even gone so far, and one here in Madison County, that in lieu of the child being tossed from household to household, the judge has ordered that the child remains in the primary residence and the parents have to go.
That's interesting.
Have you seen that?
I have seen that. That's generally in a divorce action, obviously, but they call it nesting. And so they will let the children stay put to reduce the disruption and have the parents go back and forth. I've seen that be successful, and I've seen that go wildly wrong as well. So I see it could go across the gambit as far as the rest of that goes.
What is the deciding factors for determining how much child support and or how much alimony?
So those are two separate issues. Child support in Alabama is a math equation. We have a guidelines that we use. It's called Rule 32 of the Alabama Child Support Determination, Juvenile Administration. And what they do is they plug in gross income before taxes, which always gets everybody bent out of shape. But they put in that income, it spits out a calculation and a number, and that's how child support is determined.
So you put in the mothers and the fathers.
Put in both incomes, you put in any work-related daycare that's attached to that, health insurance that's attached to that child or children, and then it spits out a mathematical formula that tells us what that child support is. Now the court, if you go to court, is generally obligated to follow that formula. You guys can agree to something different, but the court is generally obligated to follow it unless there are some good circumstances to go away from that formula, to deviate from that formula. Alimony is an entirely different animal, okay? Alimony is only available in divorce situations. It is a need-based thing, so you must establish not only that the person has the ability to pay this alimony, that your lifestyle that you were accustomed to in the marriage requires the alimony, but that you do not have the ability to meet that need on your own without the alimony. So there's a lot of different factors that go in. But it's not a formula, and it is entirely fact-based.
All right, let's get to another email question. This one from David. What is the legal standard for a judge to use when deciding which parent gets custody when there is a divorce? My situation is long and complicated, but I want to know how a judge has to review it under the law. Does the law still favor the mother getting custody?
You know, I get that last question all the time, okay? No, our law does not favor one parent or the other. Our law favors both parents, and both parents come into the situation.
Let me interrupt. There used to be a tender years lean?
The tender years doctrine, and that used to be what we followed for a long time. They have gone away from that. We now follow what's called the ex parte couch. It's the couch doctrine, which is the best interest standard. That is the sole
So men
standard.
and women are equal of getting a small child.
In an initial action, whether it be a divorce action or sometimes parents aren't married and they go to court to establish custody rights, as I stated earlier, they go in on equal footing. So the court is determining what is in the best interest of that child. And so that standard is applied to both parents, and it's solely what does the court determine is in the best interest of the child to determine. Now, again, once the custody is determined, that burden shifts. But in this situation, in a divorce, when you walk in, the court's going to evaluate all of the factors and try to make it determine what they think is best for that child in that specific scenario. Now, the case law says, and the statutes say that you're supposed to go in, and the starting point is supposed to be some sort of joint physical custody. But the reality of it is not every situation goes in that footing, because not every situation is tailored where everybody is on equal footing when you walk into situations. But the initial starting point would be, I'm going to evaluate everybody evenly and equally to make a determination.
And these matters are tried by just a judge, not a jury.
That is the difference in what you do and I do. I don't have to talk to a jury, I just talk to a judge. A judge makes the determination, and that makes good sense if you think about it. Most people don't want all of their dirty laundry out to a jury, and a jury making a determination about whether or not they think this person was in the wrong or not. Our judges, they hear a lot of these cases. They are designed to take some of the emotion out of it. As you can imagine, juries can probably have some emotion from time to time.
So talk to us about the newer thing in the last 10, 15 years, mediation in domestic relations cases, and what that is and how it works.
Mediation is a great resource, okay? And I think our judges would not say I'm talking out of turn to say that they encourage everybody to resolve the cases amongst themselves. You are in the best position to make determinations as to what's best for your child or children amongst yourselves. Spending time in front of a judge saying the worst things about each other, it's not the best way to make determination as to what's best for little Susie. Right. Mediation is an opportunity for you and your attorney, the other party, and their attorney to sit. We generally in mediation and domestic relations, we sit in separate rooms.
Right.
Mediator goes back and forth. And their job is to take whatever emotion is in the response to the offer, filter it out, and present an offer in an effort to try to get down to what is in the best interest.
So the folks will know a mediator has no authority to decide one way or the other. They're just there to coax the parties to a meeting point.
They're just a facilitator of deals is all they are. They are relaying the information in the most favorable manner in an effort to try to get people to be receptive to accept it. You're going through a divorce, and your position on what you want to give your ex is totally different than how it's portrayed by a mediator. And when it comes from a mediator, sometimes the aggrieved party is a lot more receptive to it than when it comes from somebody else.
It takes all the heat out of it.
Correct. The idea is to hopefully get down to what the actual issues are, not what the problems were that resulted in the divorce in the first place.
So interesting. Thank you so much.
Thanks,
I appreciate you guys having me.
Appreciate
Absolutely.
you, buddy.
Coby Boswell and Tommy Siniard, lots of great information about child custody cases. Next week, Tommy and Bart Siniard will discuss car accidents. We look forward to hearing from you. In addition, we have an extra special featured guest interview with Huntsville Mayor Tommy Battle. Join us next Sunday night after the late news.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.